IEC is appealing the Electoral Court decision allowing former President Jacob Zuma to remain on the MK party candidate list for next month's elections. The court recently upheld Zuma's appeal and set aside the IEC's decision to uphold an objection against Zuma's candidature. Now, the IEC wants the Constitutional Court to rule on the Electoral Court order and dismiss MK party's appeal. In papers dated 11 April, the IEC is going to the Apex Court arguing that it received 22 objections to Zuma's eligibility to stand and upheld 2 of those objections. In 2021, the Constitutional Court found Zuma to be in contempt of court and sentenced him to 15 months imprisonment. The IEC, which is standing by its original decision, wants the matter to be urgently heard. It says that it's in the public interest and the interest of justice for finality on the issue before the polls. The IEC has approached the Constitutional Court to appeal the Electoral Court's ruling in favor of Umkhonto weSizwe Party. IEC Chief Electoral Officer Simon Mabolo had this to say.
The Commission was of the view that there's overriding and substantial interest from the public to secure a clear understanding of the interpretation of Section 47(1)(e) of the Constitution, in particular its interplay with the powers of the Commission to deal with objections that are submitted to candidates. So this matter really, or rather the appeal, it's about securing clarity so that all role players can understand what that constitutional provision is, how it ought to be interpreted, and that for the future, everybody then knows with certainty and legal clarity as to what that provision provides for and does not provide for. The reality is that the Constitutional Court is the apex court, is the highest court of the land, and it's important that clarity is sought from that highest court in the land because views are divergent. And if we were to go, for instance, to the SCA, there may well be another appeal to the Constitutional Court. So you go to the highest court that has constitutional jurisdiction for certainty and clarity once and for all. The IEC remains impartial. It remains committed to an even administration of the electoral process. This has nothing really to do against prejudice towards them. What this intends to do is to realize and procure legal certainty for this election as well as for future election. And this is not to be confused with the ballot design issues. The principles that underpin the ballot design is that the photograph on the ballot would be of the registered party leader, irrespective of whether that party leader is a candidate in the election or not. And in that regard, we've clarified that issue with MK, and in the ballot confirmation process, it has been signed on that basis and on that understanding. So there cannot be accusations of partiality. All we seek is that that legal principle be clarified once and for all, so that all role players, all stakeholders, and indeed all voters know what a correct legal interpretation is in terms of candidature, where in instances where people have convictions.
MK Party spokesperson Hlamulo Ndlela has reacted to the latest developments.
As far as we're concerned, this is clear overreaching by the IEC. And like we've always said, it's a clear desperation act. Why would they go to the extent of wanting to further this case and this matter when it's actually the actual objector who ought to be taking this matter further? It's not the IEC's role. What have they got to lose? Why are they so adamant that this matter must continue? The IEC, as far as we're concerned, continues to act in a way that is very concerning, and it's bringing about a lot of questions about their independence and in terms of what exactly their role is here. Are they now becoming a player in this political landscape? the mere fact that they're taking it to the Constitutional Court in the first place. Remember, when you submit a motion of notice to appeal, it is the Chief Justice, and it seems like it's on an urgent basis. It is the Chief Justice that ought to make that decision. So effectively what they're asking is they're asking the Chief Justice and the Constitutional Court to stop its work, use taxpayers' money to look at this matter urgently, and for what basis anyway? That's another question. But remember, the mere fact that they put in the Constitutional Court in this position, in of itself, this is becoming a constitutional crisis. Why? Because this is the same constitution that presided and over the matter of sentencing President Zuma in the first place. So Judge Zondo in himself finds himself conflicted. There's no doubt about that. He's conflicted in this matter. And the IEC now, by virtue of them bringing this case, further makes this whole process a constitutional crisis.
Sure.
But again, we're asking ourselves, why are they so desperate to even take this matter any further? IEC has got nothing to lose here. The actual objector, in the form of the doctor himself, it should be the one that advances this matter, because he would be the aggrieved party here. IEC is not the aggrieved party. They're not the aggrieved party. They just upheld an objection. They never brought about an objection.
All right, joining us to discuss this further is Tselane, Executive Chairman of the Institute of Election Management Services in Africa. Good afternoon, Mr. Tselane, and thank you very much for your time. Now, we spoke to you earlier this week, and you held the view that the IEC was probably not want to challenge the candidacy matter beyond the point of the Electoral Court because they were acting on behalf of an objector, as Nhlamulo is stating there. They didn't raise that objection, but they've since indicated that they're taking it to the ConCourt. Your views on just this development?
I think the Commission is really ill-advised and their position is ill-conceived. They should not actually be taking this position. And there are many reasons why they should not be taking this position. Firstly, as indicated earlier on, this is not their matter. But secondly, there is a matter that still has to be decided by the Electoral Court. Even though the Electoral Court has given an order, they still have to give reasons. And then we don't want to second guess the decision of the Electoral Court. Perhaps the Electoral Court will not even talk about the Section 47 in their judgment.
Which is one point. Pardon me for interjecting there, because if you read their statement carefully, they say they need clarity on Section 47, subsection 1E. So one would think there could be a myriad of reasons. It could have been the remission of sentence. At this point, we do not know. But I suppose this is one that they felt strongly about, and they're assuming that it will be among the reasons that the orders were granted in favor of the former president. So, but if we do look at that particular section, I remember that Dalim Mpofu was quite strong in his argument, asking the question to the Electoral Court, where does the IEC derive its powers to implement this Section 47, subsection 1E? And he said, nowhere. And they're of the view that no, but we are allowed to read the Electoral Court in conjunction with the Constitution, that if we can decide that a specific candidate cannot be on the list, we can also go to the Constitution and look at that Section 47 and find out what are the reasons. And among the reasons is that if you have an imprisonment sentence beyond 12 months, then you cannot stand. So this type of a matter seems as though, to a certain extent, it does need the Electoral Court to pronounce on, does it not?
The Electoral Court, not the Constitutional Court, because the matter is before the Electoral Court. I think the IEC is making an erroneous mistake in its interpretation of Section 47, because Section 47 falls under Chapter 4 of the Constitution, and it refers to Parliament. So Chapter 9 can't interfere with Chapter 4 because Section 57 of the Constitution will indicate that that Parliament has got the powers to regulate its own affairs, and therefore it does not require the IEC to regulate the affairs of Parliament when Parliament is there and then is given those powers by Chapter 4 of the Constitution. So the IEC is making erroneous mistake in terms of this particular issue. They are not the people who objected. They have powers in terms of Section 30. The chief electoral officer can object to the candidacy of any person. The chief electoral officer never took advantage of that. And then now they are appealing a judgment that does not even exist.
That's why I'm saying that perhaps is it not important for them to pronounce? Yes, they've issued out orders. Pronouncement in this instance is to perhaps furnish them with reasons as to what informed the decision to grant the orders in favor of the former president. Because when I asked Saiba Mabolo earlier this week about the difficulty when consulting with their legal practitioners, that here you've got orders that are against you, but you don't even know if you can move forward. Was that decision not to furnish them with the reasons also perhaps ill-advised or is regrettable to a certain extent, given the truncated timelines at this point, that they needed to act, but they cannot act if they don't know what were the reasons?
No. They can act because there's a court order. They don't have to wait for the reasons in order for them to act. The Electoral Court, it's an important court in terms of the Constitution, and it has issued its order. What the Commission has got to do is just to comply with that order. When they want to, the reasons and then want to deal with those, they can deal with that at a later stage. I don't understand even the urgency of the matter, because the Chief Electoral Officer talks about preparations for the next elections and how they require certainty in terms of next elections. Why is there such a hurry? Because they can wait and then until after the elections and then deal with this issue after the elections.
In that statement, they say that it will bring into question these elections if this is decided upon after. And they have complied with the order because they were requested to include him and he was number one on the MK list. So indeed, he did appear when they met that timeline to publish the list of candidates. So they complied, but for them, they feel the urgency here is that they don't want a situation where you go through with the elections and then they're called into question at some point if perhaps it's found that the Electoral Court misdirected itself in its orders.
No, but I mean, that would not be their problem. If the Electoral Court has misdirected itself, then that's a problem of the Electoral Court. Why are they intervening in a matter that does not actually concern them? But what concerns me even more, and then you also to be able to demonstrate that this thing is ill-conceived, it's when they are only trying to contest Section 47(1)(e), when there are 5 or 4 other issues in that area. So their power to exercise Section 47 does not only reside with Section 47(1)(e), it resides with all those issues. Firstly, whether a person who is in the employ of state and is getting remunerated can stand for office. And secondly, whether a member of the provincial legislature or a member of the council, the municipal council, can stand for the election and then also be a member of the National Assembly. And whether a person with who's been regarded as having unsound mind by the court of law can actually be a member of the National Assembly.
But those ones would not apply. But those ones would not apply to the president, the former president, pardon me for interjecting there, just in the interest of time. But E specifically applies to the reasons why they would then bar the former president. So yes, there's the one of sound mind and everything else, but when we talk of the 12 months or a sentence exceeding 12 months, that's the one that they confine themselves to. Just that particular 1E is the one that they confine themselves to pertaining to the former president. And then they decided to read it in conjunction with the Electoral Act, Section 30, subsection 1A, which empowers them to uphold objections.
No. Now, precisely that's where the problem is, isn't it? What is in question is the power of the Commission to exercise Section 47 of the Constitution. Why are they only concentrating on Section 1, Section 47, subsection 1E, when they're supposed to be what is being questioned? It's whether the Electoral Commission has the power to administer Section 47 in totality. So even if they wanted clarity, they've got to seek clarity in terms of the whole Section 47, because they do not have the power to exercise those powers in terms of Section 47. That is the power that is actually resident with Parliament and not with them.
Mr. Tselane, I just love the fact that you preface this whole conversation with the fact that we actually still don't know if Section 47, subsection 1E, was actually what informed the orders. But nevertheless, since they're challenging that aspect, I suppose it has become the most conversational. Thank you very much for your time this afternoon.